And we're live.
All right, thanks, Jamie. And good morning, everybody, and welcome to the final meeting of the Juvenile Justice Reform Council. We are going to forego the typical roll call this morning, and Jamie is taking roll virtually and seeing all your sign-ins and taking that, so we can go ahead and move on from there. And so I'd like to just take a moment for everybody to take a look at the minutes, and if there is a motion to approve those, I would entertain it.
So moved.
Second.
Okay, any opposition to the minutes or any corrections? All right, hearing none, we'll pass those. And we're going to move next into the report draft, but I do want to take a moment. You see on the agenda here at the end, I've got some concluding remarks. I'm going to go ahead and do the concluding remarks now and kick it off that way, because I believe with our agenda, we're going to work through the end of the meeting. So let me take a moment and reflect back on the work that we've done, and just, you know, as I was reading the draft report, I started making a correction as soon as I saw that it said that we started the listening sessions January 2020. I was sure it had to be January 2019, but it was in fact January of this year. I even went and rechecked my calendar. I was so sure it had been more than a year, but it just feels that way. So I appreciate everybody's efforts and bearing with us during these very difficult times. But we did accomplish quite a bit in this period of time, and we did get to all the listening sessions around the state, and fortunately we're able to get the benefit of those before COVID hit and really compressed our schedule. That schedule compression really put a tremendous amount of pressure on our technical assistance providers, the various institutes of justice, to take a vast amount of data and analyze it and report on it in a way that we could act. And I want to acknowledge the tremendous high quality product that Vera delivered under these very difficult circumstances and in the intervals that they had to do. And just specifically thank Marta Nelson, Dr. Selena Cuevas, Anton Robinson. For those of you that weren't here, Melissa and I were having a little conversation about whether to call someone doctor, but I want to thank you guys for the tremendous contribution and for putting up with us here in Maryland for all of our requests. I also want to acknowledge our DLS staff, Department of Legislative Services. They are sort of the unsung folks on these councils when you have the assignment of staff, and that's actually statutorily designated. It's a big job and it's a lot of work, and it's a lot of work that doesn't get recognized. But they are the ones that put together our meetings, that organize this, that call the roll for us and make sure that the vote counts are all correct, put all the materials on the website, send all the notices out. In short, they organize everything for us. And so I want to recognize Jamie Lancaster, Nick Conselman, Michael Reep, and Lauren Nestor, and I'm sure others at DLS that have contributed and helped tremendous to this. But I want to recognize you as the face of it, and that have been the ones that have done the lion's share of the work for us. And thank you for everything. And we're continuing to push you and Vera to work. I want to acknowledge all of you as council members. We've put a tremendous amount of pressure on you and exerted and taken a lot of your time and sent you tremendous amounts of materials to review with not much time to review them, and have very detailed conversations. And probably I want to thank you most for having the candid conversations that we had on these very difficult policy issues. These are important issues. They're difficult to get through. And I think our discussions were all very cordial and very much moved the conversation forward, and I think resulted in some great recommendations. I want to specifically recognize Miss Jenny Egan from the Public Defender's Office, because when you look at the work that she put forward, for each of these sets of recommendations. No matter how you feel about the policy position, the contribution was tremendous, and they were very well researched and supported by literature, and they really served as the framework of our discussions and ultimately our recommendations that we've adopted. Additionally, I want to also single out Betsy Tolentino. Usually folks on my team know that I don't like to recognize my team, but she has just done a tremendous job and so much behind the scenes that people don't really see. But she has such a command of the legal framework, as well as the knowledge of our policy and practice at the agency. She can put all that together. She's a great communicator and demystifies these subjects and puts it in plain English for all of us to understand. And she also drafted the report that we're going to review next. So I want to thank you, Betsy, for all of your great efforts and contributions to this as well. I would like to thank everyone individually, but unfortunately we don't have time. And so we're going to go ahead and move on in the agenda. The next thing we have is the report. Let me just say before Betsy starts sharing her screen and the language here, that it, of course, is unfinished. It is a draft report, but it does reflect that what we have done thus far, I believe. And today I would like us to just review the content really and focus on the recommendations. We are aware that there are probably spelling and grammar errors and perhaps language that would be preferable to this or that. And we will take all of those if you could email those to Betsy. But today we'd like to focus on the recommendations themselves and make sure that they are articulating what everybody thinks that we all agreed to. And so with that, I'm going to turn it over to Betsy.
All right, good morning, everyone. I'm going to share my screen here, I think. Let's see. And then there we go. There we go. Okay. So this is the draft, very drafty final report for our review today. I'm going to walk through it and sort of highlight some areas for you all to take a look at. If there's anything that you see that's substantive, please just shout it out. Or if it's more of a typo, grammatical type error, there's many of those in here. We just started sort of putting this together a few days ago. I also want to recognize Vera, who helped in getting the data slides and the policy summaries together based on their presentations. So you'll see those as we go throughout the report. So we have our acknowledgements here for all the people who have helped us do our work. And then the table of contents, and you'll notice there are still a few sections that we are going to be adding. I don't think, is it still on there? I think what you're seeing isn't quite catching up to what I'm seeing. So here's the table of contents, nothing really exciting there, except that you see how the report will be laid out with some overview sections. And then we get into the substantive policy areas that the council chose to review. We have our membership, and we also include our membership from 2019 through the past year and a half. We did have some transitions in membership. And so we'll just scroll through that. And then the next section is the overview of recommendations. And the recommendations are included throughout the report as we go through each policy area. But we wanted one page or a few pages here where just the recommendations were laid out for the reader. These recommendations were sort of reviewed from legislative services. Our legislative team reviewed them and listened to the meetings again. I've sent them to a few members to make sure that they're accurately reflecting what we voted on. So if there's anything in the recommendation section that does not seem accurate, please let me know and we'll ensure that that is corrected. And are you on the recommendations section at all? I have been for a while, but I'm looking at my other screen.
Yeah, it's just getting there. It's going very slow.
Yeah, it is. I'm gonna try turning off one of my screens. Maybe that will help. So just let me do that real quick. Okay. Now can you hear me?
Yes, we can hear you.
Okay, now we're gonna go back to sharing. Can we see the document?
Yes, we can see it.
Okay, so hopefully this will work a little better. So we have minimum age of jurisdiction.
Hold on. Okay, now it's back. It's back. All right, go ahead.
Okay, so now we have minimum age of jurisdiction, where we most recently voted on these recommendations. And then we go to our probation community supervision recommendations.
Hey, Sam.
Yes, happy.
Is this the time where we, if we have a comment, a substantive comment about one of the recommendations that we make it, or do you want us to wait until we go through all of them, or?
No, if it's this recommendation, go ahead.
So I was reading through this last night, and I'm just curious, were we supposed to leave out first-degree sex offense, first-degree assault, first-degree rape, or B, recommendation 1B?
So first degree assault was left off. First degree rape and first degree sex offense would be included under 1.
Okay. Under number 1, a crime punishable by life imprisonment?
Correct.
Okay. But the first degree assault, that one you're going to add?
No, that was not part of what the council voted on.
Okay. All right. Thank you.
Okay. Anything else on minimum age before I go to community probation?
Betsy, I don't know if it's substantive or clerical, but under number 1, to reflect the rest of the language that's reflected in other juvenile statute, it should say a crime punishable by life imprisonment if committed by an adult.
Thank you. Okay, and now I'm going to go to community probation, where we started out with setting a statutory length of supervision term for probation, and we had different levels based on the type of offense. If it was a misdemeanor, the initial term wasn't to extend more than 6 months, but could go to a total of 12 months if the court found that that was necessary. And then for felony, the baseline was 12 months with extensions to 24 months, and then an extra extension to 36 months if the court found after hearing if the court found by clear and convincing evidence that good cause was there to extend the supervision. And then for any offense that would be a crime that carries a penalty of life if committed by an adult, then the term of community supervision could be until the court doesn't have jurisdiction any longer, which would be until age 21. And then recommendation 3 was the recommendation that created the process and law to allow a court to return a petition back to the Department of Juvenile Services for an informal adjustment. Number 4 prohibits the use of detention or commitment for a violation of a technical violation of probation.
Betsy, just 1 second, Delegate Pippi.
So on number 3, did we leave off a victim? Did we vote on that?
We did vote on this. This is, I think, very reflective of what we voted on. This was a piece of legislation that was proposed to the General Assembly last year, and the recommendation mirrors that legislation that was supported by the Office of the Public Defender, the Department of Juvenile Services, and the state's attorney. All those parties in the court, because those are the parties in the case, would have to agree to send the case back to the Department of Juvenile Services. So the victim's voice is sort of carried through the state's attorney.
So should we not list that in there, or you're saying we shouldn't list it?
It wasn't part of what we voted on.
Okay.
I mean, Delegate Pippi and Scott, if it helps, I can't imagine any prosecutor agreeing in a courtroom without at least consulting with the victim. I don't know anybody who would do that. So if that makes you feel a little better.
I mean, I'm not going to cause an issue with it. I'm just, it's either written or it's not written, but okay. Thank you.
Thanks. Okay, number 4, we voted to prohibit the use of detention or commitment to DJS due to a technical violation of community supervision as already defined in the Correctional Services article. And then recommendation 5 is a large recommendation that essentially requires the work group to come together to evaluate, inventory, collect data regarding evidence-based services in Maryland. All right, so I'm going to go to juvenile detention utilization if there isn't anything in that section. Okay, number 6 would require courts to consider the findings of a validated risk assessment when making detention decisions. Recommendation 7 would require that a child's detention status be reviewed by the court every 14 days. And recommendation 8 would require DJS to develop and submit to the court and parties a community release plan within 10 days of a detention decision. Recommendation 9 prohibits the use of detention for an offense that would be a misdemeanor if committed by an adult, unless that offense was a handgun charged under the criminal law article or public safety article, or the child has been adjudicated delinquent 2 or more times in the previous 12 months. Number 10, excuse me, I'm not going to go through each bullet, lists several things that the JJRC wanted the department to report on within 1 year and provide that report to the Maryland General Assembly. Many of these deal with our sort of how we operate detention and the services that we provide. And that's everything for juvenile detention.
Secretary, I had one more comment if I could.
Go ahead, Delegate Pippi.
So on number 9, did we have a discussion, and listen, I apologize if we discussed this thoroughly and I just can't remember, but did we talk about because I was looking through some of the data and there was a big portion of misdemeanors under pretrial, under pre-adjudication detention, it was like 45% was a misdemeanor category. It's a very large category. So my question is, if we kind of remove that away, did we talk about putting everyone on pretrial supervision? Or
I think we did have conversations about that data and specifically, and this recommendation would not prohibit the utilization of alternatives to detention or community detention for this group, such as electronic monitoring, GPS, evening reporting centers, and just regular pretrial type supervision.
it doesn't require it, right? So, I mean, the only thing that's required is that we don't have the option for pre-adjudication detention, but there's no requirement in lieu of that, right?
Correct. It would be an available option to use any of those alternatives that I mentioned, if the court so ordered.
All right, thank you.
Okay, number 10, we went through already. All right, so that's everything for detention, and then I'll move on to out-of-home treatment programs.
Mr. Schellenberger, go ahead.
So I'm on number 10. Limitations on the use of electronic surveillance and community detention for children on probation. I must have been exhausted by the time we got to this one. But I mean, shouldn't we be a little more specific there? I mean, it's just general limitations. And if we're really trying to scale back on, regular detention, isn't the use of electronic surveillance, a very relatively unobtrusive thing to do for a juvenile? I'm sure Ms. Egan will have a comment on relatively unobtrusive. I don't know. I just don't. I don't know. I don't remember us having a great discussion about that.
Scott, and we did not discuss each of these bullets in great detail because it was just requiring the department to write a report about these things. So it wasn't forwarding any specific policy recommendation or change to our current statutory construction or even our operation. It was required that DJS write a report about these topics. And then I think just to clarify, electronic monitoring and the use pre-adjudication is definitely different than the use post-adjudication. The current law allows for the use of electronic monitoring post-adjudication, but I think what I would envision this section of the report to look like is when we would use those things and data related to the effectiveness of using electronic monitoring such as GPS post-adjudication.
Okay.
Maybe the concern that Scott has is with the initial words limitations on. If we just took those out and said the use of electronic surveillance in community detention, that would not imply that the only thing we're going to be concerned about is limiting it, but how we're going to use it, how we're going to apply it, et cetera.
I guess, Mr. Chair, we can accept a request to make that change, but that was the language that was voted on, so I think it would have to be through a motion.
I'll let Scott make the motion if he wants to.
Well,
Yeah.
is this a substantive change? I don't think this is a substantive change. If it's just to clarify that we just want a report generally, and if that was the intention, and I'll go back to Ms. Egan because you wrote this one, I believe. Was there an intention there that we need to be aware of, or is it okay to just say we want to report on this like all the other stuff that's in here?
No, so there was some intention to the limitations on electronic surveillance. For example, DJS reports very extensively on the average daily population of detention facilities, average length of stay, all of those data points, but don't report on those same issues for young people on electronic surveillance. So for example, we don't have a publicly accessible way of saying how many kids were put on an ankle monitor and were they for serious offenses or were they for minor misbehaviors. The intention is not just to report on or to create new limitations, but to report on and provide guidance on what those limitations are, right? What are their policies on how they advise their case managers when they advise their case managers to request electronic surveillance? What are those limitations? What are those guidance points? That's the intention of that language, right? So, because right now that isn't provided.
It sounds like you're asking for the contours of our policy when you say limitations, like we can do this, but not that. Is that what you mean? Okay.
Yes.
So could I change it to on the policies and utilization?
Criteria.
Okay. All of those would be fine.
All of those would be fine with me. It's the word limitations that implies we got to change it going down. Let's study it and then decide what we have to do.
But can I just chime in real quick, because I don't want to, we got a presentation from Vera that basically said three things in it that to this point, that the typical kid on probation is there for a misdemeanor, that the typical kid on probation is deemed low risk by the Department of Juvenile Services, and that the typical kid on probation is on electronic monitoring or GPS monitoring. That is a huge misalignment. And so the point of this is an alternative to detention or an alternative to confinement, I understand GPS and electronic monitoring as that, but as shown in the data, it is not being used as an alternative to confinement. It is being used for young people who should never be anywhere near confinement based on the other policy recommendations we're making right now. So I'm not that concerned about the language, but I think in having this conversation after the fact right now, I think it may be missing the context, which was that we were given a lot of data that showed the #1 program in DJS. It's very different than the vision that we're talking about in this Juvenile Justice Reform Council. The #1 program used is a bracelet on a kid's ankle to monitor where they're going. Not all the kinds of services and evidence-based stuff and pro-social stuff that we're talking about, but this tether. And so I just say, I'm okay with the language, but let's give it the context of why limitation was there based on the data presentation we got from Vera.
Okay, so look, I don't want to spend too much time on semantics of this thing. This is, I want to just put it into context. This is a recommendation for the department to provide a report. So, you know, Nate, I appreciate your comments and I understand, but I don't want to spend too much time on this. Can we, let's, Betsy.
I mean, established criteria. Established criteria would be fine.
There you go. Established criteria.
Yeah.
Sounds good.
And if you establish criteria that is a low bar, then you'll report to the legislature and Delegate Pippy or Senator West can write a bill and tell you not to do it that way. But you are just providing the information.
Okay.
Okay, are we good with this?
Yep, I'm going to take that as a non-substantive change. Let's not vote on it and move on to the next.
Okay, anything else left in detention? Okay, we're going to move to out-of-home treatment programs. Recommendation 11, prohibited use of commitment to DJS. If a child was adjudicated delinquent for an offense, that would be a misdemeanor, unless the adjudication is for a second or subsequent offense involving a firearm, or found in violation of community supervision for a technical violation, as already defined in the Correctional Services article. Recommendation 12.
Real quick on that, 11.
Go ahead, Delegate Pippy.
On A, and it might just be a wording thing, is the subsequent offense involving a firearm, or is that only applying to the second or subsequent offense, or is that does that also apply to the initial offense? Am I reading that?
The council voted on, for example, the first offense involving a misdemeanor charge that involved a firearm would not be, a commitment would not be available. But if there was a second or subsequent offense involving a firearm, then commitment would be available to the Department of Juvenile Services.
There has to be 2 firearm offenses in order for this to kick in.
Correct.
Okay, thank you.
I'll just note that applies only to the mere possession, because that's the only one that's the possession offenses, which are the misdemeanors, right? If it was used in an offense, almost all the offenses where it is used in any way, displayed or threatened are felonies.
Correct. Yes, just the misdemeanor. So if you had like a robbery with a firearm, you would be able to be committed to the department because of the felony offense. Okay, number 12 is another report for DJS to write, which is establishing a plan to have a more regional sort of based approach to providing residential community-based services. Oh, yeah. Making sure each region has non-residential and residential services. Number 13 just ensures that DJS makes certain that there's comprehensive education in all DJS facilities. And 14 requires DJS to ensure that all contracted programs offer access to technical vocational education training, as well as our DJS facilities, so contracted and DJS facilities. And and I think that's everything for out-of-home treatment programs. Okay, and then we'll move on to diversion. We got through 2 recommendations at the last meeting. Those are included here, which is to require informal adjustment for all first referrals for misdemeanor and nonviolent felonies. And secondly, to eliminate the requirement of victim consent, but require the department to make reasonable efforts to contact and notify the victim of the department's decision and invite the victim to engage in restorative practice.
Scott, go ahead.
So, I mean, everywhere else, we do make an exception for the misdemeanor of possession of a handgun. I mean, do we really want to have informal adjustment on possession of a handgun?
This is how we voted it. I guess I'll let the chair lead this part of the discussion.
Okay.
Well, thanks, Betsy, for that.
Well, I think if there's going to be a suggestion to change that, we need to do that probably more formally.
Yeah, and I think we may have perhaps overlooked that because we did make that exception in a number of areas. And if Scott, if you're in making that a motion, I think we can hear that.
I would make that a motion.
Is there a second?
Second.
Okay, any discussion about accepting misdemeanor handgun?
So I just have a quick question. Would that mean that this would make it still available and possible, right? So if 4 kids are arrested in a car and they're all charged with the misdemeanor, it would the misdemeanor possession of the handgun, diversion for the 3 kids not sitting on top of the seat would still be available, just not mandatory. Is that my correct interpretation?
That's my intent. That's my intention.
Okay. Yeah. Just so you know, like, I have no objection to that amendment.
Thank you. Jenny just clarified my concern and question as well. I just wanted to point out that just because we're allowing for informal adjustment doesn't mean the case and the child are not still vetted by the state's attorney as well as the department.
Totally agree. If you need to put an extra sentence in there, I'll agree to that.
Okay, is there any opposition to the recommendation as amended? And I'm going to just wait a second so that Betsy can finish ending it.
I'd probably clean up the language a little bit, but I think this gets to what firearm offenses are not mandatory informal adjustments, but maybe an option.
Okay, so we'll clean that up a little bit, but I think we've got the substance in there, and we can move on. And that is the accepted, general language. All right, go ahead and continue, Betsy.
Okay, and then the other one was regarding the victim consent and the requirement that's placed on the department to contact, notify, and engage the victim in restorative practices. So we do have a few more diversion recommendations that we'll take up after we finish going through the report. I think that was the most important part, getting through these recommendations and making sure that language is accurately reflected in the report. We'll do a background page about the JJRC, how we got here, the preliminary report, and some things that we did in 2019. Section 2, and I'm going to go through this relatively quickly so that we have enough time for everything else today. Section 2 is an overview of our statewide listening sessions. I will highlight over 530 people participated in the listening sessions. I think that's wonderful. And we had a great partnership with the local management boards to really sort of help implement those sessions. Section 2, this section very much needs some editing, and this is the topic selection and prioritization. So this section will talk a little bit about how we got to the policy areas that we discussed, the survey, the listening sessions, as well as discussions in the council. And then you'll get into the policy areas. So each policy area has a section within the report. Minimum age is first. We'll do an overview of current Maryland law, a policy summary, indication where you can find the full policy report that Vera put together, the key findings, where you'll see some key data slides that highlight the issue, as well as some bullets that explain those slides, where you can find the full data report, and then the recommendations. And then we go through that. And as you review this, please let me know if there's anything missing, a piece of law you think that is required, and we'll get those in. Next is juvenile probation, and it will flow in the same format with current Maryland law.
So Betsy, I'm gonna just interrupt you for a moment. I just want to sort of summarize a little bit, and if you have other things you want to present, I'll certainly let you finish. But that's the rhythm of the report. You can see how it's organized, and I would ask the council members to please, review it, because we're going to count on you all as proofreaders and as members that are. This has got all of our names on it. Let's make sure that everything's correct in there. And send all those things in. But I'd like to, if you have discussion about the organization, now that we've been through the topics, if there's anything about the organization, you can look at all the slides. These are all data slides that we've already seen. These are Vera's slides. We've just put them in a format that fits in the report. Is there anything about the organization that anybody has any concerns or issues with? Okay. Betsy, is there specific things you want to cover, or can we sort of get to the end here?
I think we can definitely get to the end. Each section flows just as the first for every policy area. And yeah, just share with us. Once over the next few days and probably a little bit into next week, we'll be fine tuning the report. Of course, probably putting in a few more transition sentences and things like that, editing, adding in the final recommendations. So you'll get another version of this report probably sometime early next week, and then we'll ask you to review it and then provide any final feedback. Our goal is to make sure there's a report available to the General Assembly when at the beginning of the year.
Okay, and of course, Betsy, you'll make all the edits in the full report that we did to the recommendations in the summary sections, and they should be mirrored. And as Betsy said, we'll email this out for a final review, give everybody a chance to give additional feedback. But at this point, if there are no other questions, or it looks like Dr. Sickman, you have a question?
Of course, because, we can't progress. Now, one thing that struck me as sort of an omission, and I don't know if it's just because some of the sections aren't there yet, there isn't any real discussion of trying to address, study further, or have the policies that we've, recommended address racial and ethnic disparities. That's been a thread throughout all of our discussions, and to have it not there front and center and maybe even thrown into each discussion as to we hope that these recommendations will make improvements to the situation, I think it's harmful.
I think that's a really great suggestion, and it is intended to be in that JJRC sort of background section. The racial and ethnic disparities will have its sort of own page. That was work we did in 2019 when we had the racial and ethnic disparities presentation from Ms. Gary, and when the council agreed to sort of think through each policy recommendation through that lens. And I also think it's a good suggestion to add in at the beginning part of the recommendation page. So I will put some language together and add that in.
Doctor, it's also somewhat addressed in recommendation 5, with that study group who are going to be looking at things. And it does mention that maybe it could be a little clearer, but
Well,
number 5.
but you know, we talked about it, I think yesterday. Was it yesterday, Marta?
We did.
Discussing the draft, that it was not in there yet, and that we definitely need to put language in, because we did adopt a race equity lens. That was actually the first thing that we did as a group to vote on. So that is going to be in there, and Betsy sort of went over that background section and left it blank, but that's going to be in that sort of area of the report, and we'll put some other language in there as well. Rosemary, you had a question or comment?
Yes, thank you, Secretary. When we did the priorities, if you look in the report, you'll see that education was one. We determined as a group that we would not have time to address it. I would like somewhere in this report to just reference that and say that while we think it's important and it's a priority, we ran out of time, and we would suggest that this task be assigned to whatever group you think. I think that's what we talked about when we decided we didn't have time for it.
I think I agree, Rosemary. I think that's very accurate. And that, yes, we would have to explain that priority section in the report, and that's definitely the intention.
Thanks, Betsy.
And if you have language, and I'm not suggesting, Rosemary, you need to draft anything, but if you have language that you think would work there and you want to send it in, please do, particularly for these parts of the report that are not recommendation stuff, but things that we discussed and wanted to either pass on or have in our report. If you've got some thoughts, please send those in. Any other questions or comments about the draft report?
I got a question, and that is, if all of these recommendations were in place now, do we have any data on how it would affect the current population of the youth detention centers, the youth incarcerated facilities? And this might help in terms of racial equity. Do we have data on how many young people and their whether they're minorities or not, and whether or not it would reduce the current number of people in facilities, and how does that break down on racial grounds? Any data like that?
Well, we don't have data because we haven't made the changes. I think what we would probably need to do is develop a forecast. And, you know, when we do forecast models, one of the, you know, or sometimes often many of the variables that you have to account for are changes in the law and how that will impact the population in the future. And we do an annual forecast of our detention and committed populations. And we would absolutely be forecasting with law changes. And we can do that as an exercise, but we don't have that, I think, right now. I didn't want to cut off Marta. You may have had a comment there as well, or.
Other than the data that's on the slide and in the report does talk about the percentage of people who are in detention and in commitment for misdemeanors. So with that change in recommendation for misdemeanors, except for repeat offenses of various kinds, you would imagine everyone, you know, in that shade of color would no longer be in detention or commitment. We also look at it by race, but I don't think the slides in the report necessarily have it by race and charge, but that may be in the bigger report that we gave. So there's some indication. You can just eyeball it by looking at those color, you know, parts of the charts, but I think a projection is probably the more accurate way of figuring out.
Well, assuming that the recommendations are turned into legislation, which will be introduced in the coming session of the General Assembly, wouldn't it be helpful to have that forecast at the time these bills come for a hearing, to say if these recommendations are, if this legislation were to be passed, here's what we forecast the future would look like?
I think to some extent, the department would have to put some of that data together to be able to comply with the request from legislative services to fill out our fiscal and policy notes.
I would suggest that for some items, Vera did bring in information from other states that have made similar changes to their legislation. that could inform that forecast or projection that you make.
Yeah, so I mean, we're not going to be able to probably produce a forecast based on these recommendations for this coming session. But I think, looking at the recommendations themselves, when you make a limitation and say we can't detain for this, then you can look at that category and say, well, all these kids would be eliminated from detention. And that part, yeah, we could easily sort of, get the big picture stuff and see that it would result in a decline in those populations and probably ballpark the magnitude. But yeah, we can certainly follow up with more detailed forecasts.
And then to conclude this, and I know you want to move on, there are a lot of facilities, and Jenny Egan showed us some statistics recently about how underpopulated they are all across the state. So once there's a forecast done, wouldn't it be possible for DJS to make recommendations about shutting down some of these facilities, because we just don't need so many staffed facilities, and we could consolidate and save the state a lot of money?
Absolutely, and that is the purpose of doing those forecasts. I mean, is to the number one goal that we have with doing the forecast is to understand what our bed space needs are. Do we have enough beds? Do we need more? Do we need less? And then how do we, that drives our capital plans, that drives our operational budget. So you're absolutely right. Those forecasts would be critical to making those determinations. I think right now, the concern I would have is that the way that we forecast populations is through, a method called time series analysis. And we have a year of data right now that is unquestionably different than all of the other prior years and would skew our forecast. So I think it's going to be difficult to give you a good forecast based on this data, because I don't expect it's going to remain this way now that the vaccine is rolling out. I think there will be long-term impacts pushing the population down because of COVID. I do believe that's going to happen, but the extent to which that is the case is really hard to predict. And so getting a forecast done, I think we're going to need to see some more data to do a accurate forecast. But I think we can look at the data prior to COVID, look at these reforms and get a picture of this is what the population will look like moving forward in terms of the mix, right? With the level of kids, we're going to have fewer misdemeanors, more kids that are there for felonies, and the levels of the kids are going to be higher and so forth. So yeah. Any other questions or comments? All right, we have some recommendations to take up, and we had a work group that we put together in the last meeting consisting of Nate, Scott, Jenny, and Betsy to look at diversion recommendations. And I'm sorry, Jenny, I'm going to call on you without much notice, but as one of the work group members, can you walk us through well, we'll call it the subcommittee report.
And if you need me to share my screen, just let me know. I have those ready.
Yep, I need Betsy to share her screen because she wrote them down. Thank you, Betsy. So we went I think we had consensus. It wasn't a long meeting, but we went through the various recommendations that Betsy's going to put up on the screen. The first one was to separate out children in need of supervision from the juvenile causes statute. We actually think that needs a lot of tinkering and some real in-depth discussion. So we just agreed to table that recommendation for longer in-depth discussion, because it would require a lot more stakeholders to weigh in on how that should be accomplished and where that should be moved in the statute. So we dropped that first recommendation. And now let me open, okay, Betsy's pulling up the first recommendation that we have for this group is to narrow the definition of delinquent act to exclude the following conduct or school-based conduct. The context for this is that Maryland passed one of the most progressive statewide code of conduct for young people that requires graduated sanctions for misbehavior at school, and we don't want kids who are getting consequences at school to then be pushed into the juvenile justice system. There is already COMAR language in the education statute, and so we are our recommendation is just to codify that in statute rather than regulation, and that would codify the language and the definition of delinquent acts to not include conduct which has been traditionally treated as a matter of discipline to be handled by administratively by the particular school. So that's to address lots of the school to prison pipeline issues that we've seen, and we all agreed on that recommendation. The second one would be to eliminate the requirement in 38A10 that requires DJS to forward all complaints alleging non-violent felonies to the state's attorney for review and approval for informal adjustment. So currently, DJS has to forward all felonies to the state's attorney for their stamp of approval for diversion or for pre-court supervision. This would just exempt non-violent felonies from that requirement. The next one would be to require GOCAP to issue a directive that standardizes use of diversion by law enforcement agencies and develop a model diversion policy aligned with that directive, to create a program similar to California's Youth Investment Grant Program to provide resources to community-based organizations and localities to develop pre-arrest and post-arrest, but pre-referral diversion programs. So those are the sort of three places. DJS can do post-referral diversion, but we would like to develop and make more robust pre-arrest and post-arrest diversion programs. The next would be that GOCAP would add an incentive structure similar to South Dakota's that would provide funding to localities that refer youth to community-based diversion options instead of forwarding their cases for handling to DJS, and require GOCAP or the Governor's Office of Crime Prevention, Youth and Victim Services to collect, publicly publish, and evaluate access to, use of, and effectiveness of diversion in lieu of formal youth justice system involvement. Those are the recs.
Okay, so these are coming from our work group, and so I will, entertain, let's say, a motion on the first one, and we can have discussion after a motion is made.
So moved.
Second.
Okay, any discussion about narrowing the definition of a delinquent act to not include what is traditional discipline in the school?
Question. I mean, is that somewhat vague and broad? I mean, I'm not a school resource officer or anything like that, but I mean, can we at least, are there any issues there? I mean, who makes the call on what's considered traditional? I mean, is there a list somewhere? Is that written down? Is there a non-official understanding of what those are? Or
I'll defer to our work group. If you guys had any discussion about this, it seems to me that it's probably purposely written a bit vague to allow some interpretation there, but any work group members want to respond to that question?
So Delegate, the intent was to align the statute with what the COMAR regulations are already with regard to the schools. I think it's broad because then basically any principal may be able to decide at their particular school which ones belong in which places. Oh, please take that off. So that was why it was made very broadly. For instance, not going to school, could be referred to juvenile court. Well, honestly, in Baltimore County, I think that needs to be handled by the school, not by me.
I get that side, and I'm in agreement with truancy and things like that. But I mean, is a school fight something traditionally that would be treated as a matter of discipline by the school? I mean, where do we draw the line?
And that's where, by placing the kind of the onus on the school, is this two kids walking down the hall and they knock some books out of their hand? I don't want that. Or is it a meet you after school and there's a beat down on the playground? So that would really be the school resource officer and the principal who would make the decisions about that. Jenny, was that not our discussion or our intent?
Yeah, that's the discussion and intent. And it is open for interpretation because I do think that there's a lot of, there's developmental differences, right? And we're talking about a 13-year-old who may be in a 6th grade classroom, special ed classroom versus a 16-year-old at a regular high school. The vagueness already exists in the regulation, and to make room for those sorts of distinctions.
And I think the vagueness is also not only for that reason, but also, Delegate, it can be adjusted by county. You know, what might be accepted in Frederick as a school issue might be different than what is accepted in Baltimore County. So that was the reason we kept it vague, so we could have those parameters.
Okay, I mean, my only thought would be, I'm sure you guys talked about it. I mean, is there any concern where the discretion goes too far? I mean, that's my only thought. You know, if there's a serious incident that happens and then the school decides that, you know,
So the other thing I would say is that there is guidance in that there is a state code of conduct for discipline that ranks and describes incidents of varying seriousness from a level 1 to a level 5. And the state already and MSDE already laid out really elaborately what those different offenses are. And those ones that are more serious that require referral to law enforcement are mapped out in the state code of conduct. So I do think that schools have an enormous amount of guidance around discipline, and what is normally handled as a course has been hammered out over years in an educational context. So I forgot to mention that that statewide code of conduct exists and describes what levels should be handled as a matter of course, which rise to suspension, and which may rise to expulsion or higher levels of discipline.
And
so do we want to reference that in the recommendation, or?
Well, let me ask this question. I mean, what I see here is that this is a recommendation directed at the school administration about how they act. And so if there is an incident at a school, then and the school decides to handle it administratively. In other words, they say, okay, we're going to, you know, put you in detention or after school detention or whatever as your consequence. And the victim of that offense doesn't agree, they are still free to come in and bring a charge if that's what they want to do. But this recommendation would be about the administration, about how the school, that's how I see it, is how the school would act. Would the school administration do something? Am I misinterpreting that?
No.
Yes and no. I think that is mostly correct. That's who it's targeted at. I do think as a defense attorney, I could use that to argue to the court, but that would be post referral and all of those things, that it should not be a delinquent act. So I do think it can.
I'm not going to drag this out, but the way this is written, and I could be wrong, but even if, and I don't know what that degree of the state guidelines you reference, I don't know if there's a broken down in a category of 1 to 10, 10 being the most severe, but the way I'm reading this is it would seem that a school could, even if it was the most severe, I mean, would they still have the option of saying this is traditionally treated as a matter, you know what I mean? Could they still handle it administratively without having to refer to it as a delinquent act? I mean, is that not explicitly written down? You know what I mean? I mean, it gives them the option of kind of deciding whether they want to treat it as a delinquent act, even if it's the most severe on that list. Is that not true?
Can I ask the question? It seems to me, and correct me if I'm wrong, this is trying to help get at the school to prison pipeline, and just being on the ground in schools, it seems that at times administration and from talking to school resource officers, sometimes they're asked to handle situations that they don't even want to get involved in, but administration sometimes presses them to get involved in situations that schools should be handling. And when we were just talking about a race equity lens, if we're trying to apply a race equity lens and trying to make sure that we're putting things in place that will help to not push students, specifically students of color, into the system, it seems like we're just trying to line up what's already kind of statewide in place with the Code of Regulations, just give them further guidance with this piece here. Am I wrong, Jenny and Scott?
No, I think that's right. And to Delegate Pippi's point, this is already what administrators are required to do. It is already in the education COMAR regulations. And so I do think that that requirement for them to make that determination already exists.
Rosemary, go ahead.
Hi. I was going to support what everyone said because that's true. That is there and everyone knows to use it. I think, though, that because we weren't part of your discussion, it may very well be that it would also not resonate with the General Assembly if they don't understand the background, and they may not. So maybe incorporating by reference what Jenny and Scott talked about, because administrators do have a significant amount of leeway. We already had to follow this. And when perhaps in my school, I would have handled it one way, in somebody else's school, they would have handled it another way. But usually that's what this allows, is for you to take the culture of your community and to use it to frame what you do. And I think if we incorporate by reference the code of conduct, because it is pretty significant and it is supposed to be used, it might be a good reminder for people.
So if we need a second to that, I think just a simple cross-reference to that code of conduct would probably straighten that out. And Delegate Pippi, yes, a number 10 could be handled within the school, but don't forget, as Sam mentioned, which is also true, you know, all the victim's mother or father has to do is go to juvenile services, talk to the police, or frankly, call my office, and, you know, phone calls will start being made, and maybe that number 10 gets changed. So there are a lot of alternatives and other avenues that can be followed to make sure the case get handled the way that people want it to be.
Okay, so we have a friendly amendment to make a reference to the school code of conduct. Betsy, can you add that reference in? And so we still have a motion and a second with that amendment. We're still in discussion. Melissa, you have a comment?
Betsy's typing. Let me kind of ask a question. Again, sort of as a researcher data person, when there is that level of discretion for school administrators, that means there's also a wide latitude for bias to creep in. Do the schools keep data and report data on use of school discipline by race, and, you know, so that can be better understood? And I don't know that it's our place to put in a recommendation that they do so, but I would really want that.
They do.
Good. So that, yeah.
Okay, any further discussion on the amended motion? And Betsy, we lost your screen, so if you are typing any amendments, we cannot see them.
Right, yeah, I only had a PDF, so I'm converting it to Word, so.
Okay,
Yeah,
so,
but the amendment is to just reference the school code of conduct.
yes.
Correct.
So if everybody can remember the language, which is not to include, or delinquent acts do not include conduct which has been traditionally treated as a matter of discipline to be handled administratively by the particular school, with a reference to the code of conduct. That is the recommendation that has been now amended. Any further comment before Jamie calls the roll?
Okay. Then I would call the question.
Okay, Jamie, go ahead and call the roll, please.
Senator Carter.
Well, let me ask this before you get there. Are there any objections to this recommendation as amended?
I mean, I have an objection, and I appreciate the amendment, and I realize there's probably going to be more yays than nays here, but my concern is just there's a tremendous amount of discretion, even in terms of the severity of whatever the act is. I 100% agree that I don't want people going from high school to jail for truancy. And probably the vast majority of all offenses that would be considered delinquent. But for a severe offense, I mean, if we had somebody in that administration that felt that, you know, because people are not fully developed until they're 25, that no offense should be sent to a juvenile detention facility, then I would have some genuine concern with that. So, I mean, just on that, I'm going to vote no, but I just wanted to explain that to you guys. So.
Okay, thank you, Delegate Pippi. So we will call the roll. Go ahead, Jamie.
Senator Carter.
I vote yes, and it's probably not necessary, but in explaining my vote, because I understand Delegate Pippi's concerns, is that I actually think that the school administration is in the best position to assess whether or not such a situation should be referred to the juvenile system. And nothing that we're doing would block an individual from filing their own set of charges or taking some other outside action. And so in no way would this preclude accountability if that's what you're concerned about or anyone's concerned about. So my vote is yes.
Senator West.
Yes.
Delegate Clippinger.
Yes.
Delegate Jackson.
Yes.
Delegate Pippi.
Nay.
I'm sorry?
No, nay.
Ms. Tolentino.
Yes.
Mr. Kimmerer.
Yes.
Ms. Egan.
Yes.
Judge Stomp.
Abstain.
Dr. Gilball.
Yes.
Dr. Sickman.
Yes.
Mr. Bayless.
Yes.
Deputy Commissioner Sullivan.
Yes.
Mr. Schellenberger.
Sorry, Jesse, I know what it is to be alone on these. Yes.
Ms. Davis.
Yes.
Ms. Mandel.
Yes.
Yes? Okay. Ms. Chapman.
Yes.
Mr. Fonseca.
Yes.
Mr. Houston.
Sorry, yes.
Ms. Johnston.
Yes.
Mr. Ford.
Yes.
Deputy Secretary McGlone.
Yes.
And before I get to you, Mr. Chair, is there anybody that I missed? I was going off of the attendance, but please let me know.
Mr. Campbell votes yes.
And Secretary Abed.
Yes.
And that's the vote, Mr. Secretary. We have 1 no, 1 abstention, and the remaining members voting were yes.
All right, thank you. All right, let's move on to the next item here, which is essentially a recommendation to expand the diversion authority for the department to include nonviolent felonies. Is that accurate? And we heard the description of this, so is there any motion to approve this recommendation?
I'd make a motion.
I would second.
Okay, discussion on this recommendation. All right, hearing no discussion, let's go ahead and let me ask, is there any opposition to this recommendation? Okay, we'll assume that Judge Stamm is abstaining as usual, and that this recommendation passes, unless I missed anybody. Okay, let's go on to the next one, which is eliminating the requirement that certain citations must be forwarded to the state's attorney, allowing for the use of citations for misdemeanor offenses, and allow for police citations to be resolved through police diversion or through complaint to DJS. Is there a motion on this recommendation?
I would make a motion to approve that.
I would second it.
All right, discussion on this. Any opposition? Okay, I don't hear any opposition. We'll assume Judge Stamm is an abstention as well, and that this passes. All right, the final recommendation here requiring GoCap to do a number of things. Let me ask Glenn, do you have any thoughts on this?
Yeah, so thank you, Mr. Secretary. I appreciate the intent of this, but I think it needs to be worked a little bit in that we can't issue directives to all law enforcement to do anything. And I'd have to look into these programs a little bit more, but certainly from what I understand, we would support those utilizing current funding that we have. So my recommendation actually, and I've got the current chair and the past chair of the state advisory group are on this call. I would wonder if it would be more appropriate to ask the state advisory group to develop a recommendation to my office on how we could utilize funds to develop these programs that they're talking about here. And then in terms of the directive for the standardizations of diversion, we're actually working on a toolkit for law enforcement right now to utilize that. So if we could change that from directive to toolkit, I think I'd feel much more comfortable. And I will have to say, this is I was hoping we were going to get through an entire work group or meeting without the recommendation of GoCap having to do another report, but I see you guys slipped it in on the very last day. I appreciate that.
Didn't want you to feel left out.
I appreciate that, Jenny.
Glenn, I'm sorry to say that I think there's one more in this group for you going into the youth charges of adults recommendations. So
yep.
Ready for that one?
And as Betsy, and I'd be happy to work with Betsy on the exact language on this. Again, I support the intent of all this. We're already working towards this. I think utilizing the state advisory group of Eric and agrees, and I think Heather's on here as well. And I think that would be a really good use of some of the outstanding people that we have on that group. The other thing is on the report thing. I would hope that we could utilize like a dashboard for that. So it's not maybe a multi-page, 300-page document that no one reads, and it's more of a dashboard that you would see the information.
A dashboard is a report.
Yes.
I like that.
What about language that says develop statewide model best practices or something like that in this area?
Yeah, I think that'd be great.
And just to let you know, I think the International Association of Chiefs of Police may have put together toolkits like you're talking about a number of years ago.
Yeah, I believe we're working with those folks now, actually.
Okay, so we're working on this language, which is not going to be as directive, but more of requesting things from GoCap and reports and some other things. I think we've got some language to do. Let me see. While Betsy is working on that, Glenn, I'm going to, because I think this is the last diversion recommendation, I'm going to switch gears and let her continue getting that language together so we can tee that up for a vote. But we do have a data recommendation on the youth charged as adults piece. So maybe that's the way we can sort of pivot to the next item. And we have a long one-page list here with a lot of data elements in it. And I also note that in Ms. Egan's recommendations, there are also some recommendations about data collection. So what we have, I guess I'll start with the sort of long list here. This was what our partners at Vera, as well as our data team at DJS working together sort of identified. These are the critical elements that need to be collected in order for us to do a proper analysis, a thorough analysis of this youth charged as adult population. That is what I believe this recommendation covers. But I do want to give you an opportunity to react to that. I certainly, let me apologize to you, Director Houston. I meant to call you yesterday and talk to you a little bit about this, but here it is. I think you did see it in advance, so I hope you're ready to speak about it.
I did. Thanks, Sam. I figured you're getting back at me because I wasn't at the last meeting. No, I certainly support this 100%. And we worked with the folks at Vera and with Secretary of Ed's team, the data team, and our data team as well, and our Children and Youth Division, and came up with this list of these are the data points that we need in order to collect and measure and better understand this issue as a whole. So this recommendation, I can read through all the data points if you want me to, but this recommendation is essentially requiring us to collect this data from different agencies in the criminal justice system, including law enforcement, corrections, courts, and so on and so forth. And what our plan would be to work with Probably Do It to develop a system that would allow agencies to collect this data or to input this data, feed it to our data repository. We could create some dashboards and then share it back out with folks. Mr. Secretary, if you want me to, I can read through all this data, but I usually put people to sleep when I do that.
If you would, Director, if you're prepared to make a motion to make this a recommendation, and we can have discussion about it.
Certainly. I make that motion.
Second.
Okay, so I would just ask Ms. Egan, if you have, I know that you have a recommendation, and I hope you've had a chance. I know there's been a ton of materials put at you to look at the two. Is there anything that you see that needs to be included or that's missing from the recommendation that you made?
Yeah, there is some information. Let me just, I'm trying to cross-reference as we talk. Sorry,
maybe
I apologize.
Jenny, let me give you a minute to do that and ask our Dr. Cuevas if I could call on you. I think, Selena, you've been working with the team to develop this, and can you, I know that we want to be able to disaggregate by race and other factors. Can you talk about what you saw in trying to analyze the data and what you saw as the gaps?
Yeah, I'd be happy to speak about that a little bit. So the data I received was pretty complete in terms of demographics. We asked for them to report on ethnicity, but that doesn't seem to be something that they are collecting data on because that field was missing in the Baltimore data and was mostly missing in the MDEC data. We also included, I'm not aware of what GoCap currently receives in terms of data, but based off their reports, it seems like it's basic demographics, charge level. And it's really difficult to determine what's actually happening, who's getting transferred down to juvenile court. It's kind of difficult to determine sentencing with what's going on or what's being reported on in the GOCAP report. So we really just wanted to include a variety of indicators that were both included in my data and others that would be helpful to have, even if they weren't included in my current data, but you would believe that the court is collecting data on this, and that was what informed this recommendation.
If I could add to that just a little bit, because I agree 100%. One of the challenges, and maybe I'll say it a little more directly, where we say require criminal justice agencies, including law enforcement, corrections, courts, I can't require them to do anything. So just know that from the legislators on the committee that we're going to need some support in that getting
Absolutely.
this data is tough.
Absolutely. And I do think that we recognize that your agency cannot go and require local law enforcement to do things, but it would require legislation. So that's good that you brought that up specifically. Dr. Sickman, and then if Jenny, you're ready, we'll come back to you.
I would say that one of the things you're going to make sure that you can, or at least try to do, is to distinguish what mechanism, what statute in your law is getting them to criminal court. Because if we've changed things and more kids a different proportion may end up going by just judicial waiver, you're going to want to be able to distinguish that from the ones that are more directly filed in criminal court and be able to track those reversals that come back. It may be that in this information you could tell that, but based on offense and everything, it would be much easier to have that in as a more direct thing. And if it's useful at all, I'm more than willing to share with you. We did a project a couple years ago for the Bureau of Justice Statistics, trying to get data on kids that ended up in criminal court. And we could share with you kind of what all those variables were. It's hard to do.
Yeah, I think we should maybe slightly amend the language to say that this is really a recommendation to collect this data because we couldn't find it consistently in our sources. It's not, I think, an exhaustive list of what's needed to do the analysis. This is what's missing. So maybe it's this plus what we already collect. We would continue to collect. So I think some of the things you mentioned we have, particularly around things that when you talk about waiver. We have that data in the juvenile system. This is sort of focused on the pieces that we're missing.
Right. And we can also share with you some of the examples from other states on what they are able to do. Arizona, for example, through their juvenile court, they do keep track of the ones that are direct filed, the ones that are prosecutor decision, exclusion, reverse, once an adult, always an adult. They keep track of that. California has, whether they ended up in jail, on probation, in prison, that kind of thing. So, at least you can talk to folks there and see how they actually do it.
Okay, Mr. Jenny, I'm going to stop you for just a moment. Pause. Chairman Klippinger, do you have a question?
Yeah, not really a question. And this may be nitpicking a little bit, and I think it's mostly covered there. But just to be explicit, one of the pieces of information that I think is also helpful is not just to look at the disposition of the top count. I think that was one of the challenges that we discovered as Vera made their research here, that then they looked at the top count. They didn't necessarily see whether somebody had pled or was found delinquent to a lesser count in the same set of charges. And so I think this basically gets there, but it feels like that should be explicitly laid out.
Yeah, so if I could speak to that a little bit, we are requesting data at the charge level, not at the individual level, so it wouldn't be only limited to the top charge. That's the structure of the data I received as well. So these analyses can be done. It's just a matter of having more time to do them. So with these current recommendations, those types of analyses will be able to be done going forward.
Mr. Secretary,
Yes.
being a good intelligence analyst back in the day, is it necessary for us to list out all the data that you want us to collect? Or would it be better to say that you want us to produce data and information that is relevant to this issue? Because as we talk about, I think to Delegate Clippinger point, this list is going to grow exponentially as we continue to get into it. So I think it might be cleaner to say that we want a report and data that will, and then allow us to create that system, work with the work group to develop all the individual data points. Unless you guys feel we should list out all the data elements.
Well, my recollection of the conversation, I'm sorry, Jenny, go ahead.
No, I just thought that that might get us to consensus quicker and move on, because I know we have a big vote coming up. I think that that would be a way to do it, to ask GOCAP to work on these data points with Vera and with the stakeholders to get to it. Because one thing that I saw that was missing is just data on how many people are in prison who were sentenced as adults to begin with. We know that Maryland was ranked worst in the country for human rights violations, in part because we haven't addressed Miller v. Alabama resentencing for young people who have been in prison for long periods of time. So that's another point of data that we have to thoroughly address this issue, is not just not going forward who's being charged, but what we have done for the last 25 years. We don't have any accounting for either.
So I know we did move this. So I think, Glenn, if you could amend the language to streamline it to what you were talking about, and we'll come back to you to look at that amended language, but just be more general about what needs to be collected, and perhaps some of the language Jenny mentioned about working with our folks at Vera and other places to establish what those data elements need to be.
Perhaps just something like that very first paragraph.
Yep.
Okay. So we did have a recommendation hanging out there. Are you ready for us, Betsy?
Yeah. Sorry. Okay, hold on. There you go. It's not perfect, but I think it gets what we were discussing. The request the state advisory group to develop a plan to utilize funds to support diversion activities. Request GOCAP to develop a model diversion toolkit that includes a statewide model and best practices to support expansion of law enforcement diversion programs. Require the governor's office, the Crime Control Prevention Youth Victim Services to collect and publish, evaluate access to, use of, and effectiveness of diversion in lieu of formal justice system involvement.
Okay, I believe we had a motion and a second already on the table, and this is amended language. Is that correct, Jamie? Or anyone?
I think so.
Yes,
Okay.
I made a motion and it was seconded.
Okay, so this is the amended language. Is there any opposition to the amended language? All right, we'll assume Judge Thomas an abstention and that this has passed. Okay, now let's get to the youth charged with adults recommendations. And as our tradition is, Ms. Egan, if you would please walk us through your document.
Thank you, Secretary. So as I just noted a moment ago, Human Rights for Kids in November rated Maryland as one of the worst human rights offenders for children in the criminal legal system, in large part because Maryland sends an inordinate amount of children to adult prison. But more than it sends to adult prison, it charges a huge number of kids as adults. The United States is one of the only developed nations that allows young people to be prosecuted in adult court. My argument and the brief makes the really big point is that the practice of charging children as adults makes our communities less safe. The CDC and the Justice Department both have large meta-studies that show that charging kids as adults compared to children who are treated in the juvenile system who have similar profiles have much higher levels of recidivism and go on to commit much more violent offenses than those who are given rehabilitative treatment in the juvenile system. So charging kids as adults makes us less safe. It overburdens the system and it prevents young people from growing into productive citizens. As we saw from Vera's presentation, other states are not just curtailing and ending the practices of charging children as adults, but some states are even extending the age of jurisdiction to juvenile court to 19, 20, or 21 years old. Maryland charges children as young as 14 and puts no floor on how young a child can be that is waived into court. We are one of the only states that doesn't say you can't waive a 9-year-old, you can't waive a 13-year-old. So those are my main points. It's contradicted by science, it's a waste of resources, it's vastly unpopular, and perhaps very important for us with a race equity lens, it is discriminatory. Although Black youth make up only 30% of the overall youth population in Maryland, they account for 78% of those charged in adult court. In Baltimore City, that's 94% of all children who are charged as adults are Black. What works is charging youth as, what we know is that part of the reason that's discriminatory is that charging youth as adults is a legacy of the outdated tough on crime policies and super predator myths that developed around Black youth in the 80s and 1990s. That these young people were incapable of rehabilitation. These racist notions were operationalized into law, and they've caused incalculable harm. So that's my argument for why we should end automatic charging of juveniles as adults. I provided the brief, and I can go into lots of the data. But what we see from what happens to kids charged in adult court in Maryland is that the vast majority of them either are transferred back, given time-served sentences, or have their cases, what we can't tell from the data, but about 1/3 of cases don't show up in the data. And we think that those cases from our analysis are getting dismissed or null-prossed in adult court and recharged in juvenile court because the seriousness of the charges couldn't be sustained. Our system also, by charging kids as adults, puts us in a nebulous position related to the national law and the federal law. The Juvenile Justice Delinquency Prevention Act reauthorization in 2018 has made it illegal to hold children in adult facilities. We have to change our law to reflect that. But if we're going to change our law to reflect that, we believe we should change the law to reflect that kids are kids, that all children deserve a right to rehabilitation. And that's why my recommendation is to end direct file. We should eliminate direct file for all children. Ending direct file doesn't mean that you couldn't charge children as adults. The waiver or the ability to move kids into the adult system is still applicable, would still exist. And this would simply simplify and streamline that process and make sure that all kids start in juvenile court and that we no longer waste an inordinate amount of resources on the vast majority, more than 80%, who will never be tried or sentenced in adult court. And that we use our resources to provide immediate rehabilitative treatment and provide for those children who are charged as the adults, the vast majority of whom who stay in the juvenile system. I can go through all of the recommendations, but I assume we can do that through voting, and it might be quicker to just move to discussion.
Let's go ahead and move to some discussion. Scott, go ahead.
So a couple of things. Number one, my recollection of this beginning conversation was that we didn't have enough data and we wanted to collect more data. I mean, we really are now with this discussion at the most important conversation that we're going to have. And suddenly I feel like, number one, we don't have the data. And number two, we're rushing. I mean, this really is the crux of everything. And I really think in light of the data I supplied, which is 44 pretty horrible crimes that, while Ms. Egan is correct, they could be waived up, they start in juvenile court. And that is a huge safety issue about where you keep these people, including 2 of the cases I put in here where horrible crimes happened at Hickey. I mean, that's where they're going to sit, at least in Baltimore County and some other places. So, I mean, number one, I thought we were going to get a more robust picture of data. Number 2, with an issue this important, why are we rushing on our last meeting in our last 15 minutes to try and decide on an issue that actually is incredibly important to a lot of people?
Well, you know, I'll just respond to that quickly, and then I'll call on Nate. You know, I think we said at the outset that we were going to be pressed for time, and that we would use as much time as we could to cover as many issues as possible. And you know, I'm not saying that we're going to come to consensus today, but we ought to have the conversation, and we ought to have a discussion and see how far we can take this. And that's the commitment that I've made, not to rush it, but to have that discussion, and if we can come to consensus, to vote. But Nate, go ahead.
Thank you. And thank you, Jenny, for laying all that out. I want to say a couple of things. I think just in quick response, again, about, because this came up in the last meeting, but for Maryland to comply with federal law, all juveniles, irrespective of where they are in the case, are going to have to be in juvenile settings. They're going to have to be in places. So the idea, this question again of where they are, whether the case is in criminal court or juvenile court, either way, they need to be in facilities. If not, they're not in the community, they need to be in facilities that are specifically for juveniles. So that's already there. And so I don't know why we keep going back to it. But I guess I just wanted to step back, because I agree with Mr. Schellenberger that this is in some ways the biggest thing, the crux of what we want to talk about. And I kind of want to go back to our charge, because we don't talk about it often in these meetings. The data-driven approach for increasing public safety and reducing recidivism. Best practices for young people in the justice system, limit or mitigate risk factors. Direct file goes in the face of all 3 of those things. Just does. We are not having a conversation right now even about the question of whether young people should be tried ever in adult court. That's not even the conversation. Question is about, a lot of this about direct file itself. And I guess given the charge, given what we know about what makes young people different than adults, the question here is really about, is the burden of proving that a young person ought to have their case in criminal court, shouldn't the burden be on the prosecutor, the court, to make that decision for an individual, rather than have a presumption that young people start cases in criminal court? And that's what we're talking about here. Given the racial disparities that Ms. Egan just talked about, given everything we know that makes young people different than adults, I guess I just don't get the downside of presuming that a young person is a young person, that a kid is a kid, and that we have to make the case if we think something is so extreme that they need to be tried as adult, instead of the juvenile justice system, which by definition is designed to work with these young people, irrespective of the behavior that brings them to the attention of the court.
So regarding the detention issue, Baltimore County in their adult detention center has one whole unit that's just juveniles charged as adults. So there is a way to solve this pretrial detention thing, even in the adult system. I see folks shaking their head. I'm sure we're going to be litigating this at some point, but I think that will work. But I got to ask you all, what do you do? Do you really need to have a conversation about Nick Browning and whether he should be even prosecuted or not? He executed 4 people, premeditated, 15 years old. And what about all the rest of these people? Did you read all 44 of these? Are we really going to hold all their hands? I mean, they have committed serious crimes. And I really think that we need to have a more robust conversation with way more information for a longer period of time before we dig into what I consider to be, and I think a lot of people in the state of Maryland consider to be, an incredibly important issue.
So we're going to have Delegate Pippi, Dr. Sickman, I believe Hannibal was next, and then Ms. Egan.
So just real quick, I mean, to Nate's point about the charge, I mean, one of the first thing you mentioned, if not the first thing, was public safety. And so, I mean, it would help me out if Ms. Egan would just go over what are the offenses where a juvenile is automatically charged as an adult. Could you just go over that list real quick for me?
It's a long list, so it's actually 32 separate offenses.
So we'll actually have, Betsy, if you could get that list, we can just put it up on the screen rather than hear it.
I'll do that. Just give me a minute. Keep talking.
Sure. And I'll wait for that for my brief comment, if that's okay.
Okay, thank you. We'll go ahead and go to Dr. Sickman.
I mean, I think some of the public safety stuff comes from the fact that you're not putting them in adult prison for the rest of their lives in most instances, and therefore they're back in the community and harm has been done and they're more likely to reoffend. That's just the reality. So it's short-term safety versus long-term safety. But I think that it's super important to have such an important decision in the lives of each one of those children be something that can be appealed. The decision that's made by a prosecutor when it's an excluded offense is a charging decision, and that's not an appealable decision. The fact that so many of them end up coming back to juvenile court also sort of indicates the waste of time and opportunity where juvenile system may have been able to begin working on rehabilitating that youth. And instead they're just sitting in jail with a bunch of adult criminal offenders and learning to be a better criminal rather than improving their lives.
Well, I just want to point out, I mean, obviously you guys can read what I'm reading here. I mean, when it comes to public safety, does it matter if you're being shot by a 17-year-old versus a 25-year-old? I mean, you know, public safety is public safety. The difference is that, like you mentioned, if you are a juvenile, at least there are additional options. You know, you could be put back into the juvenile services versus having to stay there. They have that option. The judge has that discretion. I mean, there's a lot of fail-safes, but I got to tell you, this is going to be a tough sell. I mean, because some of these offenses are heinous. And when it comes to public safety, I'll say it again, it doesn't matter if you're 17 or 30. You know, if you kill somebody, that's a public safety issue. So, you know, fixing and rehabilitating the individual after the fact is a different story in my mind. But you know, I mean, it's going to be a tough sell. So thanks.
Okay, I believe we have Mr. Kennemer next. And Jenny, if I could ask you to defer to Senator Carter afterwards. She's been waiting as well. Go ahead, Mr. Kennemer.
Thank you, Mr. Chairman. I just, I wanted to pointing out recommendation number 4, where Ms. Egan urges us to put the burden on the state in transfer matters. And I wanted to ask Mr. Schellenberger, do you think that you would have had any difficulty transferring Nick Browning, who premeditatedly murdered 4 people, to adult court? Do you think a court would deny a motion to do that?
No, I think that I would be able to waive him up. But my concern is, where do you hold a 6'2" person who has an IQ of 160, where do you hold that individual pending that transfer hearing, which typically, at least in our county, in order to get a very good waiver summary, you're talking about potentially a year. So, you know, Nick Browning is going to be in Hickey for a year before you have that waiver up hearing. But I candidly admit that I think just about any judge in this county, maybe any judge in this state, would have waived him up. The point is, he already had a waiver back hearing. He had that. So there is an option here. The question is, where do you start? And Ms. Egan points out a lot of these cases are waived back, but I would like to have the data on the people who are being held when their cases are being waved back versus, some of these things we don't know now. But my point is, these 44 defendants that I point out, and look, it was easy to find these 44. All I had to do is send out one email. But there have got to be more, and we have to be able to protect the public during that whole period of time when everybody else wants them to start in juvenile court. These need to start in adult court. And again, I would call for a delay when this is the biggest issue we're going to have. And Sam, with all due respect, this seems awful rushed all of a sudden.
Senator Carter.
Thanks, Secretary Abed. I just realized, Secretary Abed, how long we've been having this debate, because I went back and looked at 2013 when I sponsored legislation to stop the automatic charging youth as adults. I think I started in 2012. And the compromise for that was that we created a commission to study juvenile court jurisdiction, and you were a part of that, and some others here may have been as well. We had robust discussions at that time, so this is not a new discussion, contrary to what Mr. Schellenberger has said, but we fell somewhat short of that, and then we began to take measures to chip away at that, such as, pending the transfer, having juveniles held in juvenile facilities, such as I think we took 2 situations that we extracted them from the automatic charging of youth as adults. But in discussing simply narrowing the discussion to simply the nature of the crime, we omit that there are generally 5 factors that courts look at in deciding whether or not to transfer. And to simply focus on the nature of the crime, we're ignoring those other 4 factors, the most important of which is the intellectual and psychological development of the child. And so I think that the problem with that argument of automatically charging as adults based on the nature of the crime is that you ignore all the other factors. And I won't be long here, but I think the most significant thing that has been said is the fact that, or the acknowledgement by Mr. Schellenberger, that in those most extreme situations, there isn't a judge in the state that would not waive that child up. But to begin at adult court for any child is to ignore the plethora of brain science. And it's also to put Maryland in a state that is still not recognizing that we need to follow the science. And also we need to acknowledge that Maryland is 50 of 50 states in terms of human rights of children and how we treat children in juvenile states. States that are much more conservative politically than Maryland have already addressed this issue. We are behind. And if we don't address this now with this commission, I don't know how long, 5 years, 10 years, 20 years, until we finally conclude that we're going to do the right thing and abandon this old traditional thinking of super predator and this racially biased thinking. Because what we're not really talking about right now is the fact that these children are overwhelmingly Black. We're also ignoring the fact that there is discretion in the very charging of youth. And so where some children in some jurisdictions that are not Black would not even be charged as an adult for the same offense, Black children in Baltimore and other jurisdictions are being automatically charged as an adult. So if there weren't discretion, that might even be something that we could consider, but there is discretion even in the decision to charge. And so for all of those reasons, we would be doing a disservice to the state of Maryland and our mission in this commission if we didn't address this issue. And frankly, if we did not vote to stop the automatic charging. It's the automation that is the problem. It is the automation that has to change. If we're going to have an automation, it should be we automatically charge all children as children, and under some extreme circumstances, we can then treat them as adults. And finally, this is the only area of the law in Maryland where we treat children as adults. There is no other area where we say that a child should be treated as an adult. And that is very significant because it speaks volumes about our mentality when it comes to the conduct of children and how we criminalize them. And so if we are not going to do this, then I would argue that we're then saying that in any situation, the ability to contract, the ability to vote, the ability to drive, the ability to engage in all kinds of other adult activity, we're saying that children of any age should be able to do that. And if we're not willing to say that, then we're being very hypocritical in carving out this one area where we treat children as adults.
I believe I've promised Jenny, and I believe Delegate Klippinger also requested to speak. Jenny?
Yeah, I just wanted to circle back to the stats and the reports that we do have. We actually have reports on youth charged as adults from different legislative bodies, or the legislature has called for reports going back actually to 2008. So we have more than a decade of reports and data on this that are provided and referenced in Vera's work. And what we know is that the vast majority, that right now, a huge number of cases, almost 1,000 a year, start in adult court, and very few end up there. It is a huge waste of resources, money, and time. For those 44 offenses, as Mr. Schellenberger said, he'd have no problem moving them to adult court. No issue whatsoever. So if we're talking about what makes sense practically, economically, and in terms of compliance with the new federal law, which we're currently out of compliance with, it makes sense on all of those levels. And then when we talk about public safety, I wanted to address one thing that Delegate Pippi said. It does matter. And the Supreme Court is who says it matters if you're 17 or 35. There is an inherent difference in young people, which doesn't just mean that it's different, what happened is different, but what that person will go on to do is different. Young people are more subject to rehabilitation, more subject to change, more subject to be able to adapt and become productive members of society. When we were in this meeting two meetings ago, Delegate Klippinger said that part of what he worried about was that the length of time in juvenile court was only till age 21. But we saw in the data provided by Vera that the vast majority of kids who stay in the juvenile system stay under supervision for as long or longer than those who are kept in the adult system. We have a system that is broken because it starts in adult and then moves the vast majority of kids back. The proposal is simply to reverse that, to save money, to increase public safety, and to treat children in accordance with Supreme Court law and science.
But Jenny,
I just haven't seen.
You're still going to have a waiver.
Just a moment.
So every one of those cases, I'm going to try and waive up. And so you're still going to have a waiver summary. You're still going to have a hearing. It's just whether you go one way or the other. You're not going to save one dime, and you're going to put a lot of people at risk.
Chairman Klippinger.
I don't remember asking to be recognized. I also don't know that I remember saying what Ms. Egan just had me say, but I don't say that with any negative intent. I'm just not sure that was my point. But
apologize if I misassigned it. It could have been.
It may have been somebody else. That's all right.
My apologies, Delegate Klippinger. I did not. I thought I saw a hand up. Have I missed anybody? Because I can't see most of my screen. So if you're desiring to make a comment, please unmute your mic.
You missed me.
Senator West, thank you.
Okay. Look, we only have a couple of minutes left. I feel very uncomfortable without the data making this. All of our other decisions have largely been on a consensual basis. We have some minor divisions, but this would not be consensual. This would divide the group right in half. I'm trying to figure a way that we could sort of split the baby in half that might be acceptable and move the needle in Ms. Egan's direction. Suppose we got rid of the automatic adult jurisdiction and suggested that it would be discretionary on the part of the state's attorneys.
I mean, that's what it is now. They bring these cases to us. I mean, yeah, an officer might make in a carjacking, might make an on-view arrest of a armed carjacker. And within days, that case is in front of us. And so I don't think that solves the problem. And the other thing, again, I come back to the data. Remember, the information presented to us was, were they convicted of the lead count? And I pointed out at the last time that in fact, a lot of times, you know, you could charge first degree assault and convict them of simple robbery, or, you know, they could be charged with carjacking, convict them of simple robbery, and Vera did not capture that information. And so, I mean, for goodness sakes, we have spent more time talking about diversion than we have about this. And with all due respect to everyone who says 2008, a lot of the folks in this group weren't in that conversation in 2008. So I would make a motion that we defer this to get the rest of the information that Vera now knows that we need, so we can make a proper decision in the future. This is why we need to extend this group. And Sam, I will sit right next to you and argue in the legislature why this needs to be extended, and we need to finish this work. And this can be number one. This can be the number one thing that we tackle after this, but we need more information.
Okay, Mr. Schellenberger, I hear your motion, and I'd ask if we could put a pin in that for a moment. We did have a recommendation around the data that we were waiting on from Glenn, and I would like to get us to vote for that, because I think one of the key points that we all agree on is that we need to have all of this data. So I don't want to let this meeting expire without getting that recommendation voted on. Glenn, are you ready to discuss that?
I am. And I'm going to just read it because I'm not fast enough to share my screen probably. So this is the Governor's Office of Crime Prevention, Youth and Victim Services will work with key stakeholders to develop a data collection plan to collect, collate, and ultimately analyze data from criminal justice agencies, including law enforcement, corrections, and the courts, in order to better understand the issue of youth charged as adults at every level of the adult criminal justice system, from arrest to case resolution.
All right. Is there any opposition to that recommendation? Okay. I'm going to take, again, Judge Stamm as an abstention, and we'll take that as a recommendation of the council. You know, I think, okay, now we'll take up, Scott, you had a motion to defer this vote, or to, if you could please say your motion once again.
Well, my motion is to defer a vote on this issue until we have all the data, which I believe is they're going to collect.
Okay, is there a second?
Wasn't a part of that a recommendation to continue the existence of this commission beyond the end of the year, until such time as it's finished its work?
Yes.
Okay, so the motion is to take this up when we have all the data and continue the work of the council. We will have someone write that up, but is there any opposition to that motion?
Yes.
Let me ask you this
Yes.
first. Is there even a second to that motion? Because I haven't heard a second.
Second.
Okay, it's been seconded. Discussion. Well, I think the discussion's probably, people want to call the vote. Is that what I'm feeling?
Yes.
from the group? Okay, let's go ahead and call the vote.
Remind people what we're voting on.
We're voting on the recommendation that Mr. Schellenberger made to defer this item.
Thank you.
among other things.
And Mr. Secretary, I guess as part of that motion to extend the task force.
I think you have to separate the two.
Yeah, I'd separate the two.
Agree.
So on the motion to defer, Senator Carter.
I vote no
Jamie?
on the motion to defer the discussion or the vote. I vote yes on the extension of the work of the commission. It's a separate issue.
Senator West. Can you hear me?
Hello, did you hear me?
Yeah. I called Senator West.
Oh, I'm sorry. I didn't hear the call. I vote yes on both.
Delegate Clippinger.
I think that the legislature in this coming session will almost certainly, and again, see bills related to direct file. I think that this group should take up those issues and needs a little bit more time to actually get the data that shows what happens at the end of the day. I would say that I personally would not object to a change in this area of the law, but as for this council, I'm going to vote yes on both.
Delegate Jackson.
I vote yes for both, and in a brief statement. Look, I think we still have much work to do in this regard. Having served and run a law enforcement agency, and now being a legislator, and sort of, and coupled with serving on this particular council, by the way, I think the extension is warranted, and I think we have much work to do. So thank you.
Delegate Pippy.
I vote yes on both and agree with the sentiments from my colleagues, Clippinger and Jackson.
Sorry, I didn't hear you.
Sorry, Ms. Tolentino.
Yes, and yes.
Mr. Kimmerer.
No on deferring this, and yes on extending the commission.
Ms. Egan.
No on deferring and yes on extending. I just want to say, in terms of extending, this has been what every body who's taken up this issue has done for over a decade. Punt and defer. Deferring for 1 year means another 1,000 children will be cycled through the adult criminal justice system, even though 80% of them will never be tried or sentenced there.
Judge Stamm.
I know what I want to say, but I'm going to abstain on both.
Dr. Guilbault.
No, yes.
Dr. Lawson. Dr. Lawson. Oh, I'm sorry. I was looking at the wrong space. She's not in the meeting today. Dr. Sickman.
No and yes.
Mr. Bayless.
No and yes.
Deputy Commissioner Sullivan.
Yes to vote.
Mr. Schellenberger.
Yes to both.
Ms. Davis.
No and yes.
Ms. Mandel.
Yes and yes.
Mr. Campbell.
No and yes.
Ms. Chapman.
No and yes.
Mr. Fonseca.
Yes to both.
Mr. Houston.
Yes to both.
Ms. Johnston.
No to defer, yes to extend.
Mr. Ford.
Yeah, I just wanted to add one bit, because as a part of the state advisory group, we have monitors that go into adult facilities to make sure that they're in compliance with the JJRA and sight and sound separation. And overwhelmingly, when we go into these facilities, staff report that they do not want juveniles in these facilities because of the exorbitant amount of cost and capacity it takes to run a shadow system to make sure that youth are kept separate from adults. So in that vein, I'm going to vote no and yes.
Deputy Secretary McGlone.
Yes to both.
And Mr. Secretary, I just need to loop back on a couple of the earlier votes. I only caught the first part. I don't know that everybody knew that we're voting on two at the same time. So I just wanted to loop back to Senator Carter. I have you as a no to defer. Do you have a vote on extension?
Yes, I thought I explicitly said that I am no on defer and yes on extending the work of the commission.
Okay. Senator West?
I'm sorry, I voted yes and yes.
Yes and yes. And Delegate Clippinger, I have you as a yes to both as well. Delegate Jackson, just to confirm.
Yes, yes.
Delegate Pippy?
Yes and yes.
And Ms. Tolentino?
Yes, yes.
And finally, Secretary Abed.
I'm going to vote yes to both. I share everybody's frustration that we weren't able to get to this issue, that we didn't get all of the data. And I think that that's the worst offense that we've had. But I do think that this commission has still done, or this council has done, great work. And I do believe that we do need to continue to examine this issue. And for those reasons, I'm going to vote yes to both.
So I have 11 for no on deferring. I have 12 on yes to deferring, and unanimous for extending.
All right, you're going to have to remind me of those rules, Jamie. Does that equal that, yes, we've deferred the issue, or is that a failure of the vote?
Give me 1 second and I'll just do a quick count and I'll let you know.
Okay. While he's doing that, I'm just going to go ahead and make some remarks here to wrap up. You know, the reality is here, we ran out of time, and we do need to have a thorough discussion of this. But as I said earlier, I think that if we look at the totality of what did pass, I think we have a fairly good package here, given the constraints that we've had. I appreciate the commitment that you made, Mr. Schellenberger, and others made to looking at this very important issue of youth charged as adults. This is a burning issue here in Maryland. We do need to make progress on it. And I think if we can get either this group or a group like this to engage on that issue, perhaps that should be, you know, the primary focus of that group, so that we make it explicit that we get to that. And ensure that we pass and support the necessary changes to getting all of the data so that we do get a good picture of this. I think that's at least something that we can call an accomplishment. Jamie, are you ready?
So, Mr. Secretary, we have 24 members voting. Because there was one abstention and 12 voted to defer, I think based on the rules that were laid out, the motion did not pass because we don't have a majority of those members voting in favor.
Okay, so the official position of the council will be not to defer this issue, but to extend the council. However, we are out of time, and this is the last meeting. So, that's the position that we are in. I would love to give everybody an opportunity to give closing comments, but we are 10 minutes past our scheduled end time. So, once again, I'd like to thank you for your service, and we will be sending out the final report with the recommendations. We are going to probably ask you for a very quick turnaround on your review on that. So I would appreciate if you could put your eyes on it as quickly as possible and give us your comments or thoughts or any changes that need to be made, and we will get that out to everybody shortly. Thank you, everyone. That concludes let me entertain a motion